All right, let's talk about something incredibly boring. Something so dull, it makes competitive C-SPAN watching look like a Michael Bay movie. I'm talking about contracts, specifically a nasty little clause hidden in them. It's called forced arbitration. Sounds important, right? Maybe even fair? Wrong, so wrong. It's a secret way companies avoid facing you in a real court. Imagine you have a problem, a big one. The company messed up, badly. You want justice. But surprise, you can't sue. You signed it away. Most people have no idea this is happening. Why would they? It's buried, deep within pages of legal gibberish. You know, the stuff you scroll past to click I agree? We all do it. Who reads terms and conditions for a new toaster? Or a phone app? That's what companies count on. They sneak this clause in. It says if you have a dispute, you can't go to a judge, no jury of your peers. Instead, you go to a private decider, an arbitrator, often chosen by the company. See the problem yet? This isn't some rare thing affecting a few unlucky souls. Oh no, this is widespread. It's a corporate pandemic, and it's designed to protect them, not you. Think of it as a get-out-of-jail-free card for big business. Did they sell you a faulty product? Did their mistake cause you harm? Tough luck. You're off to arbitration, a place where your chances of winning are often slim. And the reasons why are infuriating. It's a system built on secrecy and skewed incentives. So what is forced arbitration? It's a trap, a cleverly disguised legal maneuver. It strips you of your constitutional right to a trial by jury. It silences victims. It lets companies off the hook for serious wrongdoing. From faulty cars to financial scams, from employee discrimination to, as we'll see, much, much worse. It's a quiet theft of your power, and it happens every single day, with nearly every click, tap, or signature. Welcome to the grim reality. You might be thinking, okay, John, that sounds bad, but surely it doesn't affect me. Oh, sweet summer child. If only that were true. Forced arbitration clauses are like glitter at a craft fair. They get everywhere, and they are impossible to get rid of. Think about your day. Did you use a rideshare app? Uber? Lyft? Ding, ding, ding. You've likely agreed to arbitration, bought a new phone or a smart fridge. Check the warranty. It's probably in there. It's not just tech and appliances. Planning to go to a concert? Bought tickets online? You might have waived your right to sue the venue. Signed up for a new credit card? Yep. Rented a car? Probably. Even some employment contracts have them. Meaning if your boss does something awful like discriminate against you, your only option might be this private, company-friendly process. It's astonishingly pervasive. We are signing away fundamental rights without even a second thought, multiple times a day. Companies love these clauses. Why? Because open court is public. It's messy for them. Bad publicity. Potentially large payouts decided by a jury of actual humans who can feel sympathy. Arbitration, on the other hand, is private, confidential. The outcomes are often sealed. So if a company does something terrible to one person, others might never find out. This allows patterns of abuse or negligence to continue, hidden from public view. It's a shield against accountability, bought and paid for with fine print. The sheer scope is breathtaking. Financial services, telecommunications, software, retail, even, as we'll see, essential services like healthcare. They've all jumped on the arbitration bandwagon. They argue it's faster, cheaper, more efficient, and for them, it often is, especially when they don't have to pay out for their mistakes. But for you, the consumer, the patient, the employee, it's often a one-way ticket to a dead end, a system where the odds are stacked against you before you even begin. Now, companies will tell you arbitration is fair, impartial, a perfectly reasonable alternative to those mean old courts. That's like a fox telling a chicken that the henhouse security system is state-of-the-art. The reality, backed by data, is starkly different. Studies have shown that consumers and employees fare much worse in arbitration than in court. The win rates for individuals are significantly lower, and when they do win, the amounts awarded are often a pittance compared to what a court might grant. Think about who pays the arbitrator. In many cases, especially in consumer and employment arbitration, the company is a repeat customer for the arbitration firm. You're a one-off. Who do you think the arbitrator might, consciously or subconsciously, want to keep happy? The one who brings them consistent business, or the little guy they'll never see again? It's not rocket science. This creates an inherent bias. Arbitrators know that rulings unfavorable to big companies might mean less work for them in the future. Furthermore, the rules of evidence and procedure in arbitration are often looser. There's limited discovery. That means it's harder for you to get the documents and information you need from the company to prove your case. Appeals are incredibly difficult, almost impossible. Even if an arbitrator makes a factual error or misapplies the law, you're usually stuck with the decision. It's like a kangaroo court, but you have to pay for the kangaroo's time. And the kangaroo is friends with the dingo who ate your baby. Metaphorically speaking, of course. Statistics from organizations like the Economic Policy Institute paint a grim picture. They show employees are less likely to win their cases in mandatory arbitration. And when they do, they receive far less in damages than they would in litigation. For consumers, it's a similar story. The system is designed to manage corporate risk, not deliver justice for individuals. It's efficient for companies because it efficiently makes your problems disappear for them. It's a numbers game, and the company, almost always wins. Let's talk about Uber, the app that magically summons a car. So convenient, so modern, so full of forced arbitration clauses. Imagine this. You're in an Uber. The driver is reckless, speeding, texting, and then crash. You're injured. Seriously. Medical bills piling up, lost wages, pain and suffering. Your life is turned upside down. Naturally, you think about holding Uber accountable, or at least the driver and their insurance. But then you discover that pesky clause you agreed to when you signed up. Many victims of accidents involving Uber or Lyft drivers have found themselves in this exact nightmare. They expected to have their day in court, to present their case to a jury. Instead, they're funneled into private arbitration. Consider the case of a passenger who suffered severe injuries. They believed Uber's screening of drivers was inadequate, or that Uber should be responsible for the actions of drivers using its platform. But proving that in arbitration, with limited discovery and a potentially biased arbitrator, is an uphill battle. The secrecy of arbitration also means that if there's a pattern of problems, say multiple complaints about dangerous drivers or assaults, it stays hidden. Each case is dealt with in isolation. There's no public record built up that could warn other passengers or pressure the company to make systemic changes. Uber, like many tech companies, has argued that it's merely a platform connecting riders and drivers. Arbitration helps them maintain that distance, deflecting liability when things go horribly wrong. It's a convenient shield. And it's not just accidents. There have been horrific cases of passengers assaulted by drivers. These victims, already traumatized, then face the insult of being denied a public trial. They are forced into a private system where the company they hold responsible has a significant advantage. The quest for justice becomes another ordeal. The promise of a safe ride, shattered, replaced by the cold, impersonal machinery of forced arbitration. It's a betrayal of the trust we place in these services every day. If rideshare horror stories weren't enough, let's venture into an even more vulnerable space: nursing homes. And believe it or not, massage parlors. These are places where people expect care, safety, and dignity. Yet, forced arbitration clauses lurk here too, often with devastating consequences. Imagine signing your elderly parent into a nursing home. You're entrusting their well-being to this facility. Buried in that mountain of admission paperwork, you guessed it, a forced arbitration agreement. Then the unthinkable happens. Neglect, abuse, bed sores that lead to sepsis, a fall that isn't properly handled. Your loved one suffers or even dies due to the facility's failings. You want answers. You want accountability. But the nursing home points to the arbitration clause. No court, no jury, just a private arbitrator, potentially chosen from a list provided by an industry that has a vested interest in keeping these stories quiet and payouts low. Families grieving and seeking justice are instead met with a legal brick wall. The same tactic has been used by chains like Massage Envy. Hundreds of women came forward alleging sexual assault by therapists during massages, a truly horrifying betrayal of trust. Many of these women discovered that the membership agreements they signed contained forced arbitration clauses. Suddenly, their path to justice in open court was blocked. They were forced to pursue their claims individually, in private, against a large corporation. This makes it harder to show a pattern of misconduct and harder to achieve meaningful change. These aren't isolated incidents. These are systemic problems exacerbated by forced arbitration. It allows facilities and companies to avoid public scrutiny for patterns of neglect or abuse. Each case is siloed. The public never learns the full extent of the problem. This lack of transparency means there's less pressure on these industries to improve their standards, to fire bad actors, or to invest in better safety measures. It prioritizes protecting the company's reputation and bottom line over protecting vulnerable people. It's utterly shameful. Now let's add another layer of delightful complexity to this mess: private equity firms. These are the financial wizards who buy up companies, often in essential sectors like healthcare, emergency services, or housing. Their goal? To make a quick buck. usually by stripping assets, loading companies with debt, and cutting costs to the bone. And guess what tool they absolutely adore for deflecting blame when their cost-cutting leads to disaster? That's right, our old friend, forced arbitration. When a private equity firm takes over, say, a chain of nursing homes or hospitals, they often implement drastic changes. Staffing levels are cut. Experienced nurses are replaced with lower-paid, less experienced staff. Resources for patient care are squeezed. Quality of care plummets. Predictably, bad things happen. Patients suffer. But when families try to sue for malpractice or neglect, they find that the new ownership has fortified the company with ironclad arbitration clauses. It's part of the business model. These private equity firms are experts at creating complex corporate structures, shell companies within shell companies. It's like a Russian nesting doll of liability avoidance. Arbitration clauses are a key part of this strategy. They make it harder to sue the deep-pocketed parent company, the private equity firm itself. Instead, victims are often left to arbitrate against an underfunded, asset-stripped subsidiary. Even if they win, there might be nothing left to collect. It's a financial shell game where the patient always loses. This isn't just about nursing homes. It's happening in ambulance services, where response times lengthen due to cost cutting. It's in apartment buildings, where maintenance is neglected. Private equity uses arbitration to shield itself from the consequences of its profit-driven decisions that directly harm people. They extract wealth while diminishing services, and then use the fine print to ensure they're not held accountable in a public court. It's a cynical game, and forced arbitration is their ace in the hole, ensuring their profits are protected no matter the human cost. So, who are these arbitrators? These supposedly neutral decision-makers who hold your fate in their hands? Well, they're often retired judges or experienced lawyers. Sounds respectable, right? But here's the rub. The arbitration industry itself is highly concentrated. A few large companies like the American Arbitration Association and JAMS handle the vast majority of cases. And guess who their biggest clients are? Hint, it's not you, the individual with a one-time grievance. It's the big corporations, the ones who use arbitration clauses in all their contracts. These companies are repeat players. They bring a steady stream of business to arbitration firms. This creates a powerful, if subtle, incentive for arbitrators to be perceived as company-friendly. An arbitrator who consistently rules against big businesses might find themselves getting fewer cases. It's basic economics. You don't bite the hand that feeds you, especially when that hand is writing very large checks for your services. This isn't to say all arbitrators are consciously biased villains twirling their mustaches. Many are reputable professionals, but the system itself is structured to favor corporate interests. The lack of transparency means there's no public record of an arbitrator's rulings, making it hard to detect patterns of bias. And the limited grounds for appeal mean that even if a bad decision is made, you're likely stuck with it. It's a closed loop, a private club, and you're not a member. Furthermore, the selection process for an arbitrator can also be skewed. Sometimes the contract specifies which arbitration firm to use, or even provides a list of pre-approved arbitrators, a list curated by the company, of course. In this environment, true neutrality is a lofty ideal, often compromised by the financial realities of the arbitration business. It's less like a court of law and more like a customer service department for corporations looking to resolve disputes quietly and cheaply. Your dispute, their terms. At this point, you might be thinking, well, I'll just cross out the arbitration clause. I'll tell them I don't agree. Oh, you sweet, optimistic soul. That's adorable. But in most cases, that's just not how it works. These are contracts of adhesion. That's a fancy legal term for take it or leave it. You want the phone? You want the job? You want the medical procedure from that specific hospital group? Then you agree to their terms. All of them, including that tiny little arbitration clause. There's no negotiation. You, as an individual consumer or employee, have virtually zero bargaining power against a massive corporation. They have teams of lawyers who craft these documents. You have the urgent need for whatever product or service they're offering. Try telling your new employer you won't sign the arbitration agreement. See how quickly that job offer evaporates. Try telling the cell phone company you want to modify their standard contract. They'll probably laugh you out of the store, or more likely, hang up. This lack of choice is fundamental to the problem. Companies present these clauses as if they are a mutually agreed upon term, but it's a fiction. It's a condition of doing business in the modern world. You are forced to agree, often unknowingly, to give up a fundamental constitutional right. your Seventh Amendment right to a jury trial in most civil cases. It's an erosion of your legal protections, happening one click, one signature, one transaction at a time, all under the guise of agreement. This is why it's called forced arbitration. The forced part is key. You're not choosing it because it's better for you. You're accepting it because you have no other realistic option if you want or need the goods or services offered. Companies have systematically normalized this practice to the point where it's an expected, non-negotiable part of transactions. It's a power play, pure and simple, and individuals are consistently on the losing end, stripped of their leverage before any dispute even arises. So, what can you do? It feels overwhelming, I know, like David versus a Goliath made entirely of lawyers and fine print, but awareness is the first step. You need to understand that these clauses are out there. They are real, and they have real consequences for your ability to seek justice. So the next time you're faced with a contract, whether it's for a new app, a job, or even a gym membership, take a moment, a deep breath, and actually look for it. Read the fine print. Yes, it's tedious, it's boring, it's designed to be. Look for terms like arbitration, dispute resolution, or waiver of jury trial. Sometimes they're highlighted, more often they're buried. If you find one, understand what you're giving up. In some rare cases, particularly with smaller businesses or unique situations, you might be able to negotiate it. It's a long shot, but worth trying if the stakes are high. Ask if it can be removed. The worst they can say is no. Support organizations and lawmakers who are fighting to reform or ban forced arbitration, especially for things like employment, civil rights, and consumer disputes. There have been some small victories. For instance, laws have been passed to ensure sexual assault and harassment claims cannot be forced into arbitration, but the fight is far from over. Corporate lobbies are powerful, and they love the cost-saving, accountability-dodging features of this system. Your voice, added to others, can make a difference in pushing for change. Ultimately, be a pain, ask questions, tell your friends and family about forced arbitration. The more people who understand this rigged game, the harder it will be for companies to get away with it. Don't let them quietly strip away your rights. Your right to a day in court, your right to a jury of your peers, these are fundamental pillars of our justice system. They are worth fighting for. So read carefully, speak up, and don't let the fine print be the final word on your access to justice.